Good morning. I'm Gary DeWaal, and this is Bridging the Weeks for January 17th through 27th, and today is January 30th, 2017. During the past 2 weeks, the new acting chairman of the Commodity Futures Trading Commission, J. Christopher Giancarlo, provided a preview of his priorities, while the Securities and Exchange Commission brought 2 more actions against publicly traded companies for including in standard severance agreements language that the SEC considered to impede potential whistleblowing. This past weekend saw the beginning of the Year of the Rooster for much of Asia, as well as for family and friends who also celebrate worldwide. For them I say, Gong Xi Fan Chai. So we can all go out and celebrate. Let's start our review of the past 2 weeks' developments. In a speech before CEFCON 7 on January 18th, J. Christopher Giancarlo, the new acting chairman of the Commodity Futures Trading Commission, laid out his priorities for the Commission as part of an aggressive agenda he termed Making Market Reform Work for America. Among other things, Mr. Giancarlo indicated that fixed methods of trade execution should not be foisted on swaps traders. Instead, they should be able to choose the method of trade execution appropriate for their trading and liquidity needs as opposed to imposed standard fixed methods. Moreover, he said that swaps data reporting must be fixed to better ensure full visibility into swaps counterparty exposure, and the application of U.S. swap rules should be restricted in cross-border transactions to achieve consistent global rules, not necessarily identical requirements. Additionally, Mr. Giancarlo said the CFTC will be addressing new variation margin rules involving swaps that are scheduled to go into effect on March 1st and has already delayed the close of the comment period for regulation automated trading until May 1st. I have a lot more to say on Mr. Giancarlo's agenda, as well as my own wish list for the next few years in the article version of Bridging the Week on the website. Check it out. The Securities and Exchange Commission brought and settled 2 additional actions against publicly traded companies for including at least some of their severance agreements language that required employees to waive monetary recovery for discussing any matter regarding their employment with a government agency with jurisdiction over the company. The SEC claimed that this language violated applicable whistleblowing protections under law and its rules. During 2016, the SEC brought and settled a number of enforcement actions against firms that included in their standard severance agreements language that the Commission determined potentially impeded an employee from disclosing to the SEC a possible securities law violation. All persons subject to SEC and Commodity Futures Trading Commission oversight should review their former employment and severance agreements to ensure they are consistent with regulatory requirements regarding employee whistleblower rights. CNCGC Hong Kong Limited agreed to settle charges brought by the Commodity Futures Trading Commission that, on 53 occasions from March 2013 through August 2015, the firm failed to file CFTC Form 304 reports detailing all its core cotton purchases and sales as of the close of business on the relevant Friday as required, and on 2 occasions filed late reports. In case you forgot, core cotton refers to physical cotton contracted to be purchased or sold, or actually bought and sold, for a later to be determined price based upon a specified futures contract price. CNCGC agreed to pay a fine of $150,000 US to resolve this matter. For entertainment, I invite all readers to try to find details regarding CFTC requirements regarding cotton call reports on its website. After you give up after 10 minutes or so, consider how fair it is for the Division of Enforcement to bring these types of cases, particularly against non-U.S. cotton traders. The Securities and Exchange Commission filed an administrative proceeding against Windsor Street Capital, a registered broker-dealer formerly known as Myers Associates LP, for allegedly facilitating the unregistered sales of hundreds of millions of penny stock shares and failing to file with the Financial Crimes Enforcement Network so-called suspicious activity reports for suspicious penny stock transactions that involved at least $24.8 million US in proceeds. The SEC also named John Telfer, the firm's former chief compliance officer and anti-money laundering officer, in its complaint for purportedly aiding and abetting Meyer Associates' failure to file required SARs. According to the SEC, from at least June 2013 through the present, Myers Associates sold large quantities of shares of 4 penny stocks for 2 customers. In connection with each stock, the 2 individuals allegedly represented that the stock were lawfully exempt from SEC registration when they were not. However, Meyer Associates, quote, accepted all the individual's representations at face value without further inquiry, end of quote, charged the SEC. The SEC claimed that Myers Associates and Mr. Telfer failed to file SARs despite numerous red flags of suspicious activity, including deposits of large blocks of stocks, liquidation of the stocks during periods of substantial favorable publicity regarding the securities, and transfer of other proceeds away from Meyer Associates. The SEC seeks a cease and desist order and fines for Meyer Associates and Mr. Telfer and disgorgement from the firm. And finally, E-Trade Securities LLC and E-Trade Clearing LLC, Commodity Futures Trading Commission registered Futures Commission merchants, agreed to settle SEC charges that they failed to keep electronic audit trail logs reflecting certain of their customers' orders between October 2009 and January 2014. According to the CFTC, during this time, the respondents used a third-party vendor to provide its front-end order routing system for its customers that they thought were saving the records for it. Unfortunately, the firm was not. The E-Trade entities voluntarily reported their error to the CFTC and began correctly retaining the records beginning January 26, 2014. The two E-Trade entities agreed to jointly and severally pay a fine to the CFTC of $280,000 US to resolve this matter. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.